First of all, I would like to thank Sabine and others who are interested in my work regarding crimes against animals. So thank you for inviting me to give a talk today. It is a huge honor for me. And now I'm going to talk briefly about some aspects of this broad area of crimes against animals and the international law. Because this area is fairly new, so what I have written and what I'm going to say is necessarily exploratory, provisional, and tentative, providing a few pointers and outline for further discussion and consideration. So your suggestions and ideas are most welcome. First, I would like to say a few words how I first became interested and suggested the notion of crimes against animality. I was writing about animal laws and crimes in China and in Australia. A commonality I found is that human violence and abuse of animals are, first of all, human problems, human crimes. They're universal across national and cultural boundaries. They are found in all human societies, although some crimes are unique to some particular locality or cultures. But human societies are the leading cause of pain and suffering and death and destruction and extinction of animal species. We are all guilty, all human societies, without exception, although some might be more guilty than others. Another relevant fact is that animal cruelty in China, especially those on a massive industrial scale, for instance, wildlife poaching, intensive animal farming, animal testing and experimentation, and the fur industry, for instance, they are all actually closely related to other countries. I would say that the cruelty situation in China would not have been as devastating as it has been in China without the collaboration or collusion from other countries. It is what I call the globalized animal cruelty. So China is not the only culprit. Another example I can give you is that the situation in Australia. This has been in the news in recent times in Australia. The live animal export, shipping sheep and cattle, live sheep and cattle from Australia to the Middle East and other Asian countries. This extreme cruel practice is still legal in Australia, has been legal for many years in Australia, despite the animal welfare laws in Australia. Although the current government, Australian government, has promised to ban the live sheep export in a few years. And also, it's also in the news that just last month, the UK banned live animal export. So animal cruelty is not always local to a country or to a locality, but these days they are transnational. So further reduce and end animal abuse and cruelty requires not just legal sanction and laws in different countries, but also it requires a global solutions. And here I have listed some of the areas of animal cruelty across national boundaries, and there are more. Now, back to the topic of crimes against animals, I have written about this earlier, and the citation is there about crimes against animals, and have a few working definitions. Crime against animals refers to acts or omission that are against the law and subject to criminal prosecution and sanctions. And international transnational crimes against animals refers to acts or omission that are a form of abuse and harm to animals, regardless of legality, including those committed by individuals, and also those committed or facilitated by the state, corporation, or other national and international entities. Another definition is animal abuse. It refers to any act or omission that contributes to the pain or death of a sentient animal, or that otherwise threatens the welfare of animals. Such animal abuse can be physical or mental, may involve active maltreatment or passive neglect. It may be direct or indirect, intentional or unintentional, socially approved or condemned, necessary or unnecessary, and criminal or legal. As part of the joint paper that we have been working on, and I also further developed some thinking and some ideas. Again, these are very tentative for the definition of crimes against animality. So in view of and with reference to crimes against humanity and based on the premise and commonly acknowledged scientific evidence of animal sentience, as a working definition, crimes against animality is taken to mean any of the following unlawful or wanton acts when committed as a part of widespread or systematic actions directed against any sentient animal population, knowingly or recklessly, in disregard of the possible pain and sufferings that such actions may cause to the animal population, or of the harms to the ecosystem. And here I have suggested some of these possible crimes with reference to crimes against humanity. For instance, mass killing, extermination of animal species, enslavement, imprisonment, or other severe deprivation of the generally accepted basic freedom of animal welfare in violation of rules and norms, international law, torture of animals, organized wildlife crime, wildlife trafficking, mass slaughter and capture of wild animal species for illicit wildlife trade, and other cruel and inhuman acts against animals of a similar character, intentionally causing unnecessary pains and suffering or serious injury to body or to the mental and physical health of an animal population. Further, again, with reference to crimes against humanity, I have also made a few suggestions to further develop the ideas of crimes against animality with three sets of main elements. The first one is the physical element, which includes the commission of any of the following acts. For instance, mass killing, extermination, and imprisonment, enslavement, torture, and wildlife trafficking, and other inhumane acts, inflicting serious pains and suffering or death to an animal population. The second element is the mental element, the criminal intent that cause in causing animal pains or harms. And the third element, a contextual element, when committed as part of a widespread or systematic action directed against any sentient animal population. I won't go into details and give you examples because it's still very much work in progress. We're still thinking about those ideas. And now I would like to further develop or further have some further thoughts about animal law with reference to international law and crimes against animality in international law. If you look at the standard description of a public international law, and this is what you normally would find in any standard textbook and major scholarly work about international law. These are the established subsets and areas of international law. However, I think one area is missing, that is animal law. Although international environmental law may cover some of the areas related to animals or wildlife in particular, but I think there is an emerging area of international animal law, which is not being considered as part of international law. So I put together some of the existing or potential international law governing the treatment of animals in different situations. For instance, the treatment of animals in armed conflicts, the treatment of animals in disaster situations, in natural or man-made disaster situations, humanitarian situations, the treatment of animals affected by international trade, the treatment of animals in industrial animal production, factory farming, wildlife law and wildlife crime and suicide, animals as victims of international or transnational crimes, animal rights law, crimes against animality in general. So I further try to link the laws regarding animals to the established areas of international law, and this is possibly what we have we have now, or some of them probably emerging in the near future. But I think there is an intellectual and legal case to be made to include international animal law as part of international law. So this is what I have come up with. This is just a very tentative initial description of what I think it could be like international animal law. I can't fit all the existing subcategories there, but I think this is a new area that we should try to develop and advocate international animal law as a legitimate and a valid branch of international law. And under it, you can have all these areas, all these different areas of laws regarding the treatment of animals in different situations. And some of you actually are writing about some of these areas. This would not have been feasible some 10 years ago or before that, when I first started to write about crimes against animals. But now I think, because some of you are actually writing about some of these areas now, so I think it can be justified to propose a new area of international animal law as part of public international law. But this will be a long-term project. It probably won't happen in the next year or 10 years or 20 years, but I think it is justifiable to argue the case for such inclusion. And I also would like to point it out that this is what I'm suggesting is different from what's called global international law that people have been working on in recent years, in particular by Professor Anne Peters. And some of you probably know her work better than me, but I found her description of what she calls global animal law as a new analytical lens and legal field. She said a new legal field of global animal law is emerging out of a range of subfields, including human rights law, trade law, food and agriculture law, health law, environmental law, among others, each in their transnational and international dimension. But what I'm suggesting is a little bit different. Obviously, there are overlaps and many similarities and connections. But what I'm proposing here is international animal law should be recognized and classified and developed as a subset of public international law in the substantive sense as law. And as I said earlier, we are at the very early and initial stage of the development of such area of international law. Now, if we look at the possible sources of international law with reference to international animal law, I refer you to the Statute of International Court of Justice, which lists 4 principal sources of international law. That is, conventions and treaties, international custom, general principles of law recognized by civilized nations, and judicial decisions, and teachings of the highly qualified publicists and jurists. That's their definition. And if we consider these possible sources of law with reference to international animal law, first, treaties and international conventions relating to animals, specific to animals, to the treatment of animals. We do not have many such international treaties or conventions so far, but conceivably and possibly in the future, we will have some international treaties or conventions, and we already have some, but not many, and provisions or articles in international or UN declarations, and also international, for instance, the International Organization for Animal Health. And for quite many years, actually, a group of legal scholars, international legal scholars, have been trying to, and also animal NGOs have been trying to promote the adoption of an international treaty or international convention on animal welfare. So far, it has not succeeded, but it might succeed in the future. Second one, international custom. I don't have answers to these because these are just some very preliminary ideas, but there may be some international customs that are specific to the treatment of animals that could be regarded as one of the sources of international animal law. And similarly, general principles of law, there may be some principles that are applicable specifically to animals and treatment of animals. And judicial rulings and scholarly work. And this we have fair bit now, I think. The decisions from international legal forums, for instance, the International Court of Justice and the European Court of Justice and the European Court of Human Rights, the Whaling case and the Seal case, and also I was made aware of a few recent decisions from Europe, from the European Court of Justice and also European Court of Human Rights. One particular case, just a couple months ago, the decision was handed down regarding the law for the unstunning in farm animal slaughter in Belgium. And eventually they went to the European Court of Justice and also European Court of Human Rights, but the courts all upheld the laws in Belgium, the national laws in Belgium, for the requirement of stunning of animals for slaughter. So we now have a body of laws and judicial rulings and decisions, and also we also obviously have quite a lot of scholarly work now in this area. So I think there is a strong intellectual and legal case to be made and need to be made as to developing and classifying international animal law as a legitimate and valid subset of public international law. So it is our duty, it is upon us to develop this new area of law and advocate and promote and argue our case. And back to the crimes against animality, as part of the possible recognition in the international criminal courts. But that is, in my thinking, that is only a part of the wider international animal law. That's the criminal law, crimes against animality and zoocide and wildlife crime and related criminal law. So I think there is also a broader picture, a wider perspective of animal law, international animal law, as part of public international law. As I said earlier, these are just my preliminary ideas. I would very much like to hear your opinions and your suggestions and your criticism. So that we can further develop these ideas for the eventual recognition of crimes against animality, international law, and the international animal law as part of international law. Thank you very much.